our Arlen Specter Fellows. My name is Evan Lane. I'm the faculty director of the Arlen Specter Center. I just want to briefly, because we have so much good information coming your way, introduce you to what the fellowship is, and then I'll introduce you to Professor Parakel, who's in charge of the knowledge exchange, and he can tell you the purpose of that as well. The Specter Center has been very generously gifted a certain amount of money every year to entice scholars in the field to write about the career of Arlen Specter, but more importantly about issues he was heavily involved in. Senator Specter was involved in so many important issues that it makes it pretty easy to find topics. It's a very careful vetting process. What we do is we put out an invitation across the country for scholars to show us their ideas and what they want to do and how they want to use the Arlen Specter papers. We then look at their ideas, and if they reach the best two, we select. And this year the best two was Professor Timothy Welbeck, who I'm proud to say teaches at Jefferson University in the Law and Society program. Stand up, sir. Yay! Professor Welbeck is an attorney. He is a civil rights attorney who teaches constitutional law and American government at Jefferson. And I also have the pleasure to introduce Prof Rosen. She's a Ph.D. candidate at Northwestern University, which I'm sure we all know. We're very honored to have people of such esteemed being held, especially by me with you, and you're new to me, but you seem pretty esteemed now. And again, we want to thank the Specter family for the very generous gift in putting this forward. We think it's extremely important that even though the senator has passed on, that his ideas and his legacy live on. And discussing him in places like this is a way of keeping the legacy alive. So you know, last year we had 4 fellows, and they have written 3 articles which are making their way to publication, which will be absolutely wonderful, and the other one is making its way towards a book. These things take time, but within an amount of years we have a lot of literature about the career of Senator Specter out there, and that's the purpose of it. So with this, I'd like to introduce you to Professor Parakel.
I'm Roger Parakel. I coordinate the knowledge exchange, and thank you again for coming. So the knowledge exchange is once every month, and the purpose of the knowledge exchange is in line with the objective of furthering Senator Specter's legacy, is to exchange wealth knowledge. And this time, this month, it's always special because we have the Specter Fellows present. And the way it would work is first Charlotte would begin so we have an hour in total. So Charlotte Rosen would begin and give us a talk for 15-20 minutes, and then we'll have a 10-12 minute Q&A and a discussion. But if there is anything you see on the screen that you desperately need to clarify before we go forward, you can always raise your hand and ask. But otherwise, Charlotte would go through her talk. The same thing after Charlotte, we will move on to Timothy Welbeck and do the same routine, and that'll be our presentations for today. And again, thank you for coming. And
before one thing, I'd like to, we do have a special guest today. We have Mrs. Specter. Arlen Specter's wife, but a very important member of City Council in Philadelphia and a member of a lot of different charitable causes with a very long career. So thank you.
Again, yes, well, thanks for coming. All right. Charlotte, all yours.
Again, I'm Charlotte, and I'm a history PhD student at Northwestern. And I just wanted to, before I begin, thank the Arlen Specter Center and the Specter family so much for this generous fellowship and for hosting this wonderful event. And especially want to give a shout out to Heron, Albert, Evan Lane, and Roger Parakel for their efforts in organizing this event. All right. So my group is called Lock Them Up, But Where? Making Sense of the Armed Career Criminal Act in the late 20th century crisis of prison overcrowding. On May 17, 1984, Senator Arlen Specter was getting desperate. Despite the alleged willingness of President Reagan and fellow legislators on both sides of the aisle to combat rising crime, a full-fledged corrections catastrophe was underway at the local, state, and federal level that few were doing much about. On the Senate floor, Specter began to introduce Amendment Number 3073, which would earmark $200 million intended to fix the problem of prison and jail overcrowding in state, local, and federal facilities. This is not a threat of what might happen down the road, Specter warned. We are in the midst crisis on the shortage of prison space right now. 39 states in the United States were under court orders or consent decrees that required them to reduce their prison populations. And Specter worried that if the federal government failed to intervene, the nation's capacity to lock up new criminals would grind to a halt. Specter had visited a series of prisons and jails in his own state of Pennsylvania to learn more about the issue. It's a shocking situation, Specter reported, after visiting Holmesburg Prison and the House of Correction in Philadelphia, where prisoners suffered from extreme overcrowding, lack of usable sanitary facilities, and unbearably hot temperatures, among other things. Even in smaller, rural settings, like those of Lehigh County Prison in Allentown, Specter found that as many as 4 men were sharing cells built just for one person. And these are just notes found with his papers. You can see it was when he was on the tour of Lehigh County Prison. At the bottom it says 4 men in a cell. The senator from Pennsylvania did not mince words. He warned that in the year prior, quote, prison gates were opened and some 21,421 prisoners whose sentences had not yet expired walked out onto the streets of this country. He continued, noting that across the nation, quote, sentenced criminals were set free because there was literally nowhere to keep them. This presentation will explore what I believe is one of the central paradoxes in the history of the United States carceral state. That legislators champion law and order policies that paved the way for our contemporary crisis of racialized mass incarceration, things such as mandatory sentencing, anti-drug enforcement, and the militarization of police, and yet failed to provide federal funding for prison construction and correctional administration at the state and local level, which is where the majority of prisoners in the nation are incarcerated. As a result, state and local governments struggled to reconcile their limited capacity to house more prisoners with their and some of their constituents' increased desire to punish, leading to a national crisis of prison overcrowding that fueled prisoner resistance, judicial review of correctional administrations, and a chaotic scramble to build more prisons. Despite being what many corrections administrators and politicians named at the time as the most significant challenge for the United States criminal legal system, this problem of prison overcrowding has gone largely overlooked by historians of mass incarceration. To address this gap, my dissertation examines this era of prison overcrowding and prisoner resistance, something that I'm kind of loosely calling in my dissertation right now carceral crisis, in late 20th century Pennsylvania. Contrary to presentations of the late 20th century as a period of established law and order politics, I show that politicians and bureaucrats in Pennsylvania committed their state and society to mass incarceration beyond what their budgets, political capital, and administrative capacity could sustain, leading to nearly 3 decades of institutional and political disorder in the state's correctional systems. And this is some pictures after a prisoner uprising at a state correctional institution in Camp Hill, which is in Pennsylvania, kind of outside Harrisburg. And there's lots of reasons for why this uprising happened. One of them was that the institution was extremely overcrowded, and this was in 1989. So in examining this era of carceral crisis, I hope to demonstrate that the rise of the racialized prison state was more contested and contingent than is commonly understood. A crucial backdrop to Pennsylvania's carceral crisis, and the carceral crisis in the states more generally during this period, however, is the federal government's notable failure to invest in these overburdened and quickly deteriorating state prisons and jails, despite the fact that, as I said earlier, the majority of imprisoned people in this country were and are detained in state and local facilities. So this is just from 2019, but just to kind of give you a sense of where the majority of imprisoned people are. It's not in federal prisons, it's not in private prisons, but it's in state prisons and local jails. Indeed, the 1980s actually featured a decrease in federal funding for state corrections. For example, between fiscal year 1980 to fiscal year 1983, no federal funds were authorized for state prison construction, despite the fact that these years saw the largest increase in prisoner populations in United States history, causing numerous prison systems across the country to face prisoner unrest and court orders to reduce populations. As Senator Specter lamented at a 1983 Judiciary Committee hearing on the matter, to say that the situation has reached a crisis stage is probably seriously underestimates the problem. So today I'm going to discuss how Senator Arlen Specter's flagship Armed Career Criminal Act, when analyzed alongside his parallel efforts to allocate funds for state prisons and local jails, exemplifies the federal government's paradoxical and ultimately calamitous approach to corrections in the 1980s that helped create this national crisis of prison overcrowding. On the one hand, Senator Specter worked harder than most in Congress to remedy the crisis of state prison overcrowding. On the other hand, my analysis of Specter's papers on the Armed Career Criminal Act, which I'll now refer to as the ACCA, suggests that the ACCA contributed to the very state prison overcrowding that Specter fought to address. Although Specter stands out as a legislator who understood the harm of overcrowded prisons and the pragmatic challenges of prison capacity in cash-strapped states, his simultaneous efforts to lock up more criminal offenders for longer sentences, and specifically the ACCA's core utility as a leveraging tool for local plea bargaining, which I'll get into more later in the presentation, ultimately stoked rather than ameliorated carceral crisis in the states. So Senator Specter repeatedly sought to allocate more federal funds for the construction of state prisons and jails and the federal budget, even trying to pass omnibus legislation to implement a national violent crime program that would direct $1 billion annually to states for prison construction. In 1986 and 1987, he attempted to pass an Emergency Prison Expansion Act, which, in response to increased demands for prison space after the passage of the 1986 Anti-Drug Abuse Act, would have authorized $500 million annually to alleviate state prison overcrowding for a 5-year period. He also routinely introduced legislation that would have allowed habitual offenders to be sentenced to life in federal prisons, thereby reducing the population burden on state correctional facilities. Despite his efforts, however, the Reagan administration, citing the high cost of state prison construction, balked at Specter and a few other legislators' calls to use federal funds for such endeavors, leaving states scrambling to build more prisons and or to reduce their ever-growing prison populations as a result of tougher mandatory sentencing laws. Specter's only successful allocation of federal funds to state and local prisons came through the Specter-Dole Amendment to the 1984 Justice Assistance Act, which provided a comparably paltry $25 million of matching grants for state prison construction. As Senator Dole put it, the amendment provided, quote, more of a hope chest rather than a war chest in the fight against deteriorating prison facilities. So analyzed against the backdrop of this Reagan-era federal government's negligence towards state prison overcrowding and Specter's tireless attempts to remedy the problem, the impact of Specter's Armed Career Criminal Act appears more complex than is commonly understood. Passed in 1984, Specter's Armed Career Criminal Act is largely remembered for its punitive crackdown on repeat violent offenders, or what criminologists at the time were calling career criminals. Following this criminological scholarship that argued a small contingent of career criminals were responsible for the bulk of violent crime, Specter believed that targeted anti-crime legislation, such as the ACCA, would have a major impact on lowering the crime rate. The bill, which was passed as part of the 1984 Comprehensive Crime Control Act, initially stated that if offenders first had 3 or more prior felony convictions for robbery or burglary, and then second had violated a federal law that prohibits felons from possessing, receiving, or transporting firearms, that they could then be authorized for prosecution in federal court and would receive a mandatory sentence of at least 15 years without the possibility of a suspended sentence, parole, or probation. Such a reach by the federal government into the distinctly state and local realm of criminal prosecution was unprecedented, but Specter felt it was necessary for combating sharp increases in violent crime. Citing observations from his time as Philadelphia District Attorney, Specter argued that career criminals frequently evaded harsh punishment because of continuances, judge shopping, court backlogs, and overcrowded prisons, all of which conspired to drag out criminal cases and reduce the time that so-called career criminals spent behind bars. Once passed, the ACCA interrupted this cycle by making it possible for local prosecutors to refer eligible ACCA cases for federal prosecution, where offenders would be processed in speedier federal courts, face tight bail restrictions, and receive at minimum 15 years behind bars without probation or parole. In 1986, Specter successfully expanded the ACCA scope to cover all violent crimes as well as serious drug crimes, expanding the statute's potential for punitive prosecution. So in reports and hearings on the proposed bill, prison overcrowding came up several times as a key source of local judges' hesitation to dispense long sentences, and thus as justification for the bill's passage. Although not passed with the sole intention of reducing state prison overcrowding, the ACCA did provide this added benefit of ostensibly easing state prison overcrowding crises somewhat by removing these repeat criminal offenders from state courts, and thus also from state correctional systems. Then Tennessee Congressman Al Gore, who was a supporter of the ACCA, mentioned as much at a 1984 committee hearing, stating that the ACCA, quote, may be useful as a way of dealing with the state prison overcrowding problem, which in Tennessee had certainly reached crisis proportions, with state prisons operating at 122% capacity. Yet in practice, the ACCA appears to have operated less as a means for transferring offenders from state to federal courts, and more as a tool to discipline judges deemed too lenient on violent offenders, and to provide local district attorneys with leverage for procuring tougher plea deals from criminal defendants. In other words, although the ACCA had the appearance of transferring prosecution and confinement of these allegedly most dangerous offenders to federal courts and prisons, in practice it actually contributed to the state's prison overcrowding crisis, whether it meant to or not, by bolstering local prosecutors' ability to win tougher, longer sentences within their own jurisdictions. So to be sure, the ACCA did result in some federal convictions for repeat offenders, but from what I've seen in the documentation, the numbers are not convincing. Deputy Assistant Attorney General James Knapp reported at the 1986 Senate hearing on the expansion of the ACCA that there were just 14 people serving sentences as armed career criminals as of May 8, 1986. Knapp does suggest that those estimates may be low due to lack of sufficient reporting mechanisms, and later in the hearing, Deputy Assistant Secretary for Enforcement in the U.S. Department of Treasury, David Dart-Queen, reported that the Bureau of Alcohol, Tobacco, and Firearms, which was running task forces in select cities to procure ACCA convictions, reported that the ACCA had obtained 40 convictions since the law's passage. By 1991, the BATF reported convicting 471 people under the statute. This number is not totally insignificant, but compared to the state prison and jail population at the time, which was 751,806 people, 471 appears more trivial. Now, the ACCA was always meant to serve as a supplement to states rather than a wholesale federal prosecutorial takeover. Some states already had sufficiently punitive habitual offender statutes, thus negating the need for federal prosecution under the ACCA, and Specter knew that attempting to usurp local district attorneys' power would run afoul of federalism, and he actually kind of got in trouble with that in earlier iterations of the bill. Further, part of Senator Specter's framing around the ACCA convictions was that because those convicted under the new statute were career criminals, their imprisonment had a higher impact. In other words, it was the quality, not the quantity, of the convictions that mattered. The numbers of convictions may not have been mighty, but incapacitating these individuals who were deemed chiefly responsible for the majority of violent crimes would greatly reduce the crime rate. So whatever the ACCA's impact on crime rates or its actual utility in transferring state offenders to federal prisons may have been, the more important point is that evidence suggests that the ACCA was likely worsening state prison overcrowding crises by helping district attorneys gain the upper hand in plea bargaining and thus helping them to pressure defendants into longer sentences in state prisons. For those who may not know, plea bargaining refers to when a prosecutor and a defendant make an arrangement where the defendant pleads guilty to a lesser charge or only to one of several charges in return for some kind of leniency or concession from the prosecutor. As I referred to earlier, one of Specter's biggest gripes with the state criminal legal system, based on his experience as DA in Philadelphia, was that criminal defendants had the upper hand in sentencing. Defense attorneys could judge shop for more lenient judges, and court backlogs put pressure on judges to avoid jury trials and secure guilty pleas, which often led them to offer inducements to defendants of shorter sentences or probation. The ACCA, however, provided prosecutors with what Congressman Gore called, quote, another weapon in their arsenal in prosecuting repeat criminal offenders. The threat of prosecution in more efficient and less pliable federal courts, and as I mentioned earlier, this kind of staggering mandatory minimum of 15 years imprisonment. When asked to report on the ACCA's impact in their jurisdictions, local district attorneys spoke highly of how the statute provided them with unprecedented leverage in plea bargaining at the local level when defendants were eligible for conviction and sentencing under the ACCA. Speaking to Philadelphia's experience, U.S. Attorney Edward S.G. Dennis noted in 1986 that, quote, there have been a number of cases in which a very appropriate plea bargain was reached as a direct result of the threat of the case being referred to federal court, with, of course, the mandatory jail sentence possibly imposed at 15 years in the federal system. He continued, it's just a matter of common sense that when the threat is real, when, with our detention statute, the fact that a defendant would face a probable sentence of 15 years mandatory, that is an extreme amount of leverage in the plea bargaining situation. Then Philadelphia District Attorney Ronald Castile backed up Dennis's analysis, stating that the ACCA gave local DAs, quote, a range of options. It gives us the option of taking a person with just a crime of gun possession and using the act as leverage to obtain a plea bargain. They could obtain their 2.5 to 5 years in my program, or they could have the alternative of going to see Mr. Dennis at the U.S. Attorney Office and facing an enhanced penalty of at least 15 years without probation or parole. Far from an unintended consequence, Specter had full knowledge that the ACCA would provide local DAs with leverage and promoted this feature as central to the bill's power. This mechanism ultimately fit with Specter's overall vision of utilizing federal power to help states better combat violent crime, which he believed required a program of mass incapacitation that state criminal legal systems were likely unable or unwilling to pursue on their own. Indeed, in a 1982 article in the Annals of the American Academy of Political and Social Science, Specter articulated this, quote, need for a new federalism in criminal justice, where the federal government provides remedies for precisely the points of the criminal justice process, where the system, particularly at the state level, suffers major breakdowns that jeopardize public safety by allowing dangerous repeat offenders to evade justice and resume their careers. Although often branded as a tool for removing career criminals from state jurisdictions and subjecting them to tougher federal courts and mandatory sentencing, my evidence suggests that the statute's real power lied in its ability to provide unprecedented power to local prosecutors for plea bargaining without disrupting their sacred local control over criminal prosecution. In practice, the ACCA's disruption of criminal defendants' ability to negotiate lighter sentences, and thus its role in inducing tougher and lengthier sentences at the local level, ultimately contributed to, rather than helped to relieve, the clogging of state prison systems. So overall, more research is needed to discern the precise impact of the ACCA on local plea bargaining and its relationship to the crisis of state prison overcrowding. But my preliminary investigation suggests that Senator Specter's career offers a unique lens into this paradox of a law and order era also being an era of federal government retrenchment from the very correctional systems their punitive sentencing policies were helping to rapidly overfill. Even someone like Senator Specter, who clearly saw that state prison overcrowding was an unmitigated crisis and sought to remedy it, right? Fought for policies such as the ACCA that fundamentally privileged a project of retributive sentencing, despite clear knowledge that this project would overburden correctional systems and, most importantly, heap extended harm upon incarcerated people. Such insights into this paradoxical feature of the late 20th century law and order policymaking, I hope, will allow scholars and practitioners to better identify the types of decisions that led to the rise of racialized mass incarceration. Thanks very much.
You have questions to ask for Charlotte? Yep.
So where do we stand today with all this?
That's a good question. I mean, there's lots of ways to answer that question. I mean, I think, I guess, so one of the things that my research is pointing to is that the federal government's kind of refusal to fund corrections is sort of what leads to the rise in private prisons industry. So that's kind of like one way to make sense of, although still private prisons only make a small percentage of where people are incarcerated, but there's like, for example, George Bush Sr. Has like a lend-lease program where private contractors are building prisons that are then leased to the federal government. So I think that's maybe one way to make sense of kind of the rise of private prisons. But I think still today, we see overcrowding hasn't gone away, right? There's still, I think the very nature of the carceral state is such that like if we keep sending more and more people to prison, we're always going to run into a problem of capacity, and that's always going to kind of be doing harm to people who are behind bars, I think. So I think it's kind of a cyclical problem, that we haven't quite figured out, yeah.
What influences the fact that the public doesn't really care that much about the people in jail? That it showed you Specter was concerned there were 4 people in a jail cell for one. But other than his concern at the moment, does the public really care?
I would say, that's a big question that lots of people do research on or are trying to discern, but I think, especially in the 1980s when this was sort of like an era of law and order, arguably, people were like more perhaps, how should I put this, like, the idea that people who committed crimes should be locked away and should never kind of re-enter society was more prevalent and more accepted, and I think arguably that type of attitude still remains today. It also is completely bound up in the racial politics of that era. You could think about it as sort of like a backlash to civil rights, also to kind of bigger structural shifts in the economy that were affecting already racially marginalized groups even more so, right? But at the same time, this was also an era of like retrenchment, so certain groups became even more stigmatized. Already stigmatized groups became even more stigmatized, and so people were, more okay with putting them behind bars, essentially. That's one way to think about it. I hope that that's changing, and there's been a lot of discussion around mass incarceration, how to fix it, how to reform it, how to rethink what it means to quote-unquote be a criminal or to commit a crime, and sort of rethink whether that should make someone unable to re-enter society. So I'm hopeful about that, but I think remains an issue today. Yeah.
So does the late senator have any contemporaries in the U.S. Senate today? There's Meek Mills who's come out,
Yeah.
now everyone's backing that. So, but in the U.S. Senate, is there anyone as interested as the late senator?
That's a good question. Because I'm a historian, I feel like I don't know. I probably should know more about what's happening with the contemporary scene. I guess I will say that, for example, there is a lot of bipartisan energy around prison reform, as is evidenced by the First Step Act, which was passed, I believe, last year, which is a bipartisan major prison reform bill. Had support across the aisle. Van Jones is really involved in it. I know some people might have seen that across their timelines. And I will say that a lot of activists and prison reformers across the spectrum have issues with that. So meaning that I think there's still a lot of work to be done. There are lots of people that have critiques of whether the First Step Act is actually going to end up reducing the number of people behind bars, if it's actually pushing hard enough. But I think that you're pointing us to an interesting issue, which is that now today, mass incarceration, the issue of prison reform has become a bipartisan issue. However, I think it remains to be seen whether those efforts are going to actually reduce the number of people behind bars. And so I think we're still kind of waiting to see.
Well, Oklahoma just let out 500.
This is true, yeah. So there are efforts across the country, absolutely. And for example, they just closed Rikers in New York City, although they are going to open some more facilities, which activists on the ground were asking them not to do. The idea being if you build more prisons, you will always fill them, so don't build more prisons, right? So that's kind of an ongoing conversation in New York City, I know, but yeah.
Nicely presented.
Yes.
Thank you. Oh, yeah.
Oh, no,
Yeah.
we got
What about the that's like that three strikes law that you were talking about, right? Is there any talk about that, changing that, or,
Yeah, I think there are lots of different movements, I would say, kind of that are operating at different points of the criminal justice system. So absolutely getting changes in sentencing. I know, for example, I live in Chicago and I do some work out there, like prison education work at Stateville Prison, which is a maximum security prison there. And I know that many of the students are wanting to get parole back in Illinois. So there are some states where in this kind of flurry of law and order policy making in the 80s, some states got rid of parole, right? So that's kind of one big effort that's trying to mitigate these impacts and at the very least allow people that have been in prison for 15, 20 plus years the ability to come out on parole, right? And not, kind of remain in institution. So yeah, I think that there's tons of organizing and activism happening. Sentencing is one piece, parole is another piece. Trying to not build new jails is another piece, right? So there's lots of stuff going on. Yeah.
Jen, Julia?
There's one back here.
Oh.
In your research, has there been any information concerning how the shift from a state prison to a federal prison courtroom, how that impacted the people who are going up for these crimes, their decision making? So they might not have been guilty, but because of this, either you go here or we shift it to a federal court, how has that historically played into the plea deals?
Yeah, that's a really good question. I think, unfortunately, I don't have a ton of good data on the question of how these plea bargains went down as a result of the ACCA. That's something I'm really interested in, to sort of figure out if you're a criminal defendant and the prosecutor is saying to you, we can send you to the U.S. attorney for this, or you can take this deal, kind of what actually happens with those deals. I will say though that, I guess one of the things that was attractive to Specter and others at the time who supported the ACCA and to local prosecutors was that unlike in state criminal justice or court systems where at the time there was all these backlogs, it was administratively not very efficient, right? The federal court system didn't have any of those problems, right? Because of I forget the exact year, but there's a Speedy Trial Act at the federal government that requires that trials get wrapped up in 60 days, so that avoids like the issue of delays. Bail was tighter at the federal level, so so it was quite, if you're a criminal defendant and you end up getting transferred transferred to federal prosecution, like, you were going to feel those effects in a serious way. I think what we know less about is your question, which I think is what your question is pointing us to, is what happens to people where ACCA was used as leverage, and then how that affected their experience in the court system. I'm not totally sure how, I want to learn more about that. I'm not totally sure where I'm going to find it yet, but I think that's a really important piece of this project.
All right, I think we can move on to the next one, but thank you so much. You're up.
Good afternoon. So, as I was introduced earlier, my name is Timothy Welbeck. I'm a civil rights attorney, so I'm an attorney by training. I also have the pleasure of teaching here in the Law and Society program. Particularly, I teach constitutional law in the fall, and I teach American government in the spring. I also teach some classes at Temple periodically as well, do some writing periodically in that. And I wanted to thank Mrs. Specter and the Specter family for allowing for this fellowship, and also the committee for awarding me with this fellowship, and also my colleague Charlotte, who just gave an excellent presentation. My presentation is entitled, "You Can't Win When You Can't Get Out of the Cage, Understanding the Violent Crime and Control and Law Enforcement Act of 1994 and its role in expanding the modern prison industrial complex." So, the title of my research ultimately complete as an allusion to The Wiz, which came out in 1978. That's before some of you all's time. But for those of you who are unaware, it's an adaptation of L. Frank Baum's classic children's novel, The Wizard of Oz. And it was a retelling of a story centering it in urban America. Particularly, it was centering it in Harlem. And it was released by Universal Pictures and Motown. And so it had an array of stars from the time. We had everyone from Quincy Jones to Michael Jackson to Diana Ross. It was a who's who. Michael Jackson played the role of the Scarecrow. And in an iconic scene, when we're introduced to him as the Scarecrow, he is on a pole, and there are some crows who are telling him the 10 Crow Commandments and how he is lacking in power to be able to frighten them from being able to do what they choose to do in that moment. And it is there that Michael Jackson begins to lament his lot in life as a scarecrow who's stuck on this pole, who's ineffective in the one job that he has. And one of the things he begins to sing is, "You can't win, you can't break even, and you can't get out of the game. People keep saying things are going to change, but they look like they're staying the same." And so I borrowed from this language that Michael Jackson used to capture the present lot in life for people who have found themselves under the supervision of the criminal justice system here in America, those who are incarcerated, because many of them find it difficult to re-enter. This idea is that you can't win when you've been in the cage, and when you can't get out of the cage, it's like your record follows you as though it's a shadow. We've heard references to Meek Mill earlier. Meek Mill was under the supervision of the criminal justice system for 11 years. And for that period of time, he talked about it was like his record followed him like this pernicious shadow. And so to that end, our understanding, at least of some of the decisions made by prior generations, has shifted to some degrees, but the numbers are still staggering. I'm going to share some of them with you. Many of them are numbers that we're familiar with, but the United States incarcerates more people than any nation in all of recorded history. The United States literally has more bodies in prison than China, and China has nearly 4 times our population. And it's to that end, when you think about a nation that has 25% of the world's prison population, but only 5% of the world's population, it's either speaking something to the pathology of the people within the confines of the country, or the pathology of its policies that's governing people's behavior and the like. And so to that end, the thing that people have lamented even more is this idea of the racial disparities that are inherent within the criminal justice flagrantly representing and appearing across the generations. Particularly, Michelle Alexander has noted in the new Jim Crow that there are more black men in prison than there were slaves in 1850. And so when you think about the staggering nature of mass incarceration and what it looks like, these bodies in prison, and many of them are languishing in prison for most of their adult lives, it leads many people to inquire as to what is the cause of something like this. And many colleagues and scholars have looked to prior eras in American history and looked at things like convict leasing that came on the heels of slavery during the Reconstruction era and how that began to create the first prison boom in the United States. Others look to the contemporary era and they'll look at the war on drugs and the war on crime that began as a rhetorical device in the late 60s and then became more of a policy agenda in the 80s. I chose to look more closely to the mid-90s when the infrastructure for mass incarceration was erected on a foundation of rhetorical devices and policies from a prior generation. And so to that end, I'm looking more closely at the 1994 crime bill and its lasting implications for the modern prison industrial complex and what that means for people who are languishing in it at this juncture. And considering that the late Senator Arlen Specter was not only a workhorse but had a renowned legal acumen, in terms of my research, what I chose to do was to consider this like a legal scholar. And so I looked closely at what other legal scholars have presented, whether that is the writings of Stephen Chippendale, who's an attorney in DC, who wrote a law review article called More Harm Than Good, Assessing Federalization of Criminal Law, or whether that is Professor Kathleen Brinkney, who is a professor at Washington University at St. Louis, or looking at the writings of Michelle Alexander, looking at the writings of the late Derek Bell, looking at the writings of Leon Higginbotham and the like, and then also looking more closely at first-hand accounts of people who were on the ground, who were helping to not only alter some of these policies, but some of the architects of these very policies as well, and to look more closely at how the law began to weave itself into this broader pattern of what we're seeing now. The system that we call mass incarceration, the prison industrial complex and the like, there have been an array of different titles and ideas, but ultimately what the terms are trying to codify is this notion that America incarcerates entirely too many people, that there are too many people under the supervision of the criminal justice system, and that they are often there for too long. 97% of the people under the supervision of the criminal justice system have not even been to trial yet. And that speaks to the level at which our system not only criminalizes people, but it houses them in ways that is frankly a violation of their due process claims. This idea that you could functionally be under the supervision of the criminal justice system and that the state can seize your liberty before you have an opportunity to defend against the charges that have been brought against you, and that there is increasing pressure for people to take deals for crimes that they have not committed, and ultimately as a means in which to come closer to securing their freedom. So to that end, in the mid-90s, the nation was witnessing a heightened attention to criminality, to violent crime and the like. There was escalating numbers of violent crime, and in January of 1994, 40% of Americans said that violent crime was something that they thought about regularly and that they wanted the nation to address. And President Bill Clinton, as he prepared to sign this act in September of 1994, he not only talked about this rising tide that was clamoring for the government to do something to lock away these people, some of whom were given these names like super predators and the like. He began to reference the individual stories of people who had fallen victim to violent crime. So he named several mothers who had lost their children. He also went as far as to talk about how our children in the United States are losing their parents, losing their siblings to violent crime, and that they had now finally reached a point where we had moved beyond partisan wrangling and moved beyond showboating and had come to the point where something would be done. And so with that said, we got the House Resolution 3355, which is commonly called the Omnibus Crime Bill, or the 94 Crime Bill for short. And with that, it brought together an array of different features that have cascaded through the criminal justice system that have now had lasting impacts. Some of those my colleague has mentioned before, so for the sake of brevity, I won't go to exhaustive detail with them, but you will see and heard of things like 3-strike penalties with enhanced sentencing for people who are committing a third felony, mandatory life sentences for repeat offenders. There was a $9.7 billion allocation in funds to hire 100,000 police officers across the United States. And what these policies and a number of others began to do was have a multifaceted impact on criminality, the understanding of criminality, and the way in which communities were literally policed in the United States, whether that's the literal militarization of police across the United States, or whether that's the idea that you can have enhanced sentencing for crimes, and now people are faced with the prospects of the idea that you can now spend the better part of your adult life in prison. And as my colleague mentioned, that offers prosecutors enormous leverage, because once someone is presented with the idea of saying that you can either sit in jail and wait your trial and sit here for what could be up to 2 years and then face 15 mandatory years in prison, or you can take a deal right now and get, for, by way of example, 5 years as your sentence, you can potentially get your time served, and that can reduce it some, so you might spend 3 years in prison, and ultimately, even in a scenario like that, while it might appear advantageous to the person in that moment, but ultimately it's happening is that people are still languishing in prison. Ultimately, at times for crimes they may not have committed, or they're sitting in prison and for things that they could have been redirected for. And so with that said, what my research has begun looking at is not just the impact of some of these policies, but what were people saying about it at the time? Because many people have looked at the 94 Crime Bill with the lens of hindsight and talked about some of the impacts that it's had. We've seen people like President Clinton disavow his support of it at the time. We've seen Vice President Biden also do the same. We've seen Congressman Rangel do the same. And so, and with that said, one of the things I was interested in my research is what the lay senator from Pennsylvania think about these things, or what would he be saying about these things that we're here around today, because at the time he looked at this as one of the capstones of his legislative career, this idea of being able to take his pragmatic experience as a prosecutor to bring real world solutions to not only state policy but national policy, and help to inform his colleagues as to what are some of the best tactics in place that can be used towards thwarting what was perceived as a real issue, the rise of violent crime across the United States, the after effects of the crack epidemic, and the like. And so I was interested both in that and also the notion of how many of these policies had significant unintended consequences. By way of example, when we're looking at the Armed Career Criminal Act, the import of that at the time was not what ended up happening in terms of the way in which it was implemented. The leverage that it afforded prosecutors was obviously something that the late senator anticipated, but he did anticipate that it would be used in the way in which it was. The late senator was deeply concerned with what criminologists were at the time were calling career criminals, people who they believed were committing an inordinate amount of violent crimes at the time, and thought that targeting these types of things could be a deterrent to not only the types of crimes that these career criminals were allegedly committing, but also could, as a whole, have this broader sense of bringing safety to communities across the country and the like. Obviously, the late senator did not foresee the deep racial disparities in which some of these policies have been and would be applied. And what I am looking further into as I'm continuing my research is one more analysis of how he viewed the direction of some of the policies within the 1994 Crime Bill, in addition to how he saw the implementation of some of his policies, to the extent to which he found them to be a success, and things of that nature. Some of the scholars that I mentioned before, like Professor Brinkney, convened a symposium in 1994, and many of them offered some critical analysis to it at the time, but it's easy to highlight those things now when the groundswell of attention at the time was massively in support of something that now people are unilaterally decrying as something that was a mistake. And we've seen people protesting during the 2016 election cycle and talking about the after effects of things of that nature. And ultimately, the last thing that I also want to look more closely at is how this accelerated the overpopulation of people in state facilities, because the 1994 crime bill was something that was enacted for federal facilities and helped to set the stage for state and local governments as they began to implement further policies, enhance sentencing, using federal sentencing guidelines as a rubric for guidelines that they would use in terms of implementing enhanced sentencing and the like. And so ultimately, my research is looking at this stigma that we affix to people who we put in cages for committing crimes, and the determination of what we look at as a crime, how we classify that as a crime, and how and when we deem these people eligible and worthy to re-enter society, and this notion of a retributive model of punishment and wanting to penalize people, and rather than offering them a means to re-enter society. It's reminiscent to me of Michael Jackson sitting on a pole in 1978 saying you can't win when you can't get out of the game. And the game in this particular instance is this cage. This cage, a literal cage that people are in, and then a figurative one that begins to follow them once they leave here. And so with that, I'll take some questions from you all if you have them. And yes.
So the late senator's interest in Gaudensia, I don't know if you came across that, or they just celebrated a 50-year anniversary. Mrs. Specter was heavily involved in that because Arlen, wanted to separate the career criminals from those who suffered from addiction.
Yes, like nonviolent.
Correct. With that moving forward to the 1994 crime bill, what was his efforts in that in terms of pointing that out or saying, hey, this has been going on forever, how are we going to address this moving forward?
I think a good way to look at that is his support of the Second Chance Act. And so the idea of how the late senator looked at incarceration with the possibility of rehabilitation, and this notion of allowing people to successfully re-enter society, and noting that every offender is not the same type of offender, and so that there are some people, and by the late senator's perspective, who have demonstrated the need to be removed from society because of the heinous nature of acts that they may have perpetrated on other people, but then there are other people who did not warrant this enhanced supervision for the bulk of their formative years and the like. And so I think that's a good way to point to that and support of some other efforts that he may moving in that direction as well. Yes.
I think listening to you and Charlotte is a real contradiction, because we would all agree that keeping violent, dangerous people away from the public is a good idea. But there's no space for them, because we have so many non-violent people sitting in the jail. So what we do is we have a clash in policies. We want to protect the country and the citizenry from these people, but yet we can't, because we're too busy putting too many people in jail who are not dangerous. So I thought that was, it works against each other. You can't have both going at the same time.
It's an interesting paradigm, and it's a conundrum of sorts, but ultimately I say that it falls to the demagoguery that we have towards criminalizing certain populations and the stigma that we affix to them, and then not only affixing the stigma to them, but then allowing it to follow them for a number of years. And so I made a passing reference to Meadville earlier, but this is someone who in 2008 was confronted by a police officer who has since been discredited and who is said to have falsified evidence. And he spent 8 months in prison, and then from there he spent 11 years under the supervision of the criminal justice system for ultimately crimes that the system said that he should not have been punished for. And so he is a notable example of something that happens to people every day, and part of the reason why he has said that he wants to be the face of criminal justice reform is because he has powerful friends. You can call Jay-Z, you can call the government, you can call Beyonce, and the average person.
Can't do that.
I can't call Beyonce. And so, but his point is duly noted, and one of the things that he said is someone with the resources and the connections that he has, if he still fell prey to this system, how much more can other people who grew up on Burke Street like he did? And so to that end, I think about someone like Khalid Browder, who spent a significant amount of time in Rikers Island for the accusation of stealing a backpack, and he couldn't post the $10,000 bail that was presented to him. And so, and in Rikers Island, he was subject to constant abuse, not only by guards, but by fellow inmates, to the point that they had him in solitary confinement for nearly 2 years, and the trauma inflicted upon him from that ultimately caused him to take his life upon his release. And so, Khalid Browder famously talked about the notion that he never took that plea because otherwise he would just be another black man with a record. And so the notion of he's accused of stealing a backpack because of a false identification, and then he spends almost 3 years in prison as a consequence of that. It reflects some of the errors of our system. Another key shift in our society now is how we look at substance abuse. Thankfully, our nation has changed its mind at how we look at people who abuse substance, and we look at it as a public health crisis and are looking for diversionary methods to give people the assistance that they need. A generation ago, we were throwing people in prison for that, and there's still people languishing in prison for the very things now that we're holding symposiums for and doing specials for on television and looking for other types of medication and the like. But ultimately, that's a long-winded way of saying that you're right. We put entirely too many people in prison for nonviolent offenses. We put people in prison who have not demonstrated a need to be removed from society. And so the people who have demonstrated that they should be separated from society oftentimes fall prey to some of the things that my colleague talked about. This notion of overcrowding prevents them from being in a position to be able to be suitably removed from society. And then even while they're there, to have humane conditions while they're there. Overall, these are issues that the late senator had demonstrated that he had deep concerns for while he was alive. We saw that he's visited some of these facilities, and not only did he visit some of these facilities, but he also petitioned some of his colleagues to consider the conditions of people who were in prison and suffering from some of these conditions as well. And so part of the reason why I wanted to look particularly at this issue is because there's been renewed attention to the 1994 crime bill. And like I said, I feel like the late senator did not have an opportunity to speak from the present about the ways in which people have discussed some of the decisions that we made previously and the way that some of his colleagues have been able to do and things of that nature. Yes.
How, having worked, I'm a counselor, but having worked in halfway houses
Yes.
and with federal, state, and county probationers, how does this issue impact those that are on release? Meaning going into halfway house settings or trying to find a home plan. How has this issue caused the backlog in that respect?
So I think there are a number of ways that it impacts it. So I think you have the literal difficulty that comes with the inability for people to be able to successfully re-enter seamlessly because of the stigma that's attached to them. You have to fill out the box. So when they're applying for jobs, applying for health insurance, applying for schools, and things of that nature, applying for government assistance, they have to demonstrate that they have been convicted of a crime to some degree, and so that presents more opportunities for prejudice and discrimination against them. It limits their opportunities and enhances recidivism rates among the population. Additionally, too, you often see this larger sense of just the weight of having to carry around the stigma of being someone who has been ostracized from society, being deemed to be unworthy of being able to re-enter successfully, even if they're acknowledging that they've made a mistake and they've paid their debt to society. Last month I had the privilege of moderating a discussion with Dr. Yusuf Salam and Raymond Santana of the Exonerated Five, and they both talked about this notion of, even though they didn't even commit the crimes for which they were convicted, it's been 6 years and 8 months apiece in prison for a crime that they did not commit. And particularly Mr. Santana was talking about how even his family didn't fully embrace him when he came back. And so he had the literal difficulty of trying to find a job, even if it was menial, minimum wage jobs. He was willing to take those jobs and just did not have the opportunity to receive them. And then there are also enhanced complications too, like he couldn't work with other felons, so that also impacted the shifts that he could take, things of that nature. And then he still had family members who were telling him that he was a rapist when unfortunately he was not. And so it wasn't until decades later that still, people, not only was he exonerated, but we still have people saying that he should be punished for something that he was not. So, that he did not do. So I said all of that to say, even people who are re-entering the system and there are resources in place, the resources are often inadequate, and that's no fault for the people who are in the system working. Oftentimes these people are overworked and underpaid and are working diligently and nobly to help people to have another opportunity in life. But if anything, it speaks to the need to better fund and offer more adequate resources for these types of individuals, and also having better means in which to either expunge records, keep sentences for nonviolent offenders, things of that nature. Yes.
I was wondering if in your research, like, if it comes up with the idea of like dual victimhood, like the way in policies it seems like there's this like dichotomy of victims of crime versus like people accused of crime, but in actuality it's like the same populations that are suffering from the violent crime and being incarcerated, like over mass incarceration.
Yes. So I have encountered that, not to the extent that I would have expected it to, but both anecdotally and to a smaller degree empirically, I have seen that idea. I functionally have seen on an anecdotal level prosecutors who functionally say that people who bemoan me serving the community this way and looking at the people that I'm locking away are overlooking the fact that the people that I'm locking away often look like the people who I'm serving too. And so like that's on an anecdotal level that I've seen. Empirically, there is a rising degree of research that's talking about that, but unfortunately, a lot of this is still dichotomous in that people are looking at one population or the other and not looking at the totality of it. You'll ask great questions. Anybody else? Well, I want to thank you all for coming today and for listening to our presentation. Again, I want to thank the Arlen Specter Center and his family. I also want to thank the committee for awarding me this fellowship and my colleague who who had a riveting presentation. I look forward to sharing with you the finished results of the research that I'm conducting and where this goes from here. But thank you all again, and I appreciate it.
Okay, thank you all for coming. There's still a little bit of food. There's cookies, and if you don't eat them, I do. So please go in the other room. Thank you again for coming. How much you enjoy it? The area is good.
Oh, you're good.
And the thing is,